Yes.
Hello, Arizona. Good afternoon. Great to be here. Congratulations on making it to nationals. My name is Caitlin Johnston, and I am an attorney in New York City. I am also an alum of the We the People program. I did it in high school when I was growing up in Indiana. So best of luck to you. You've already accomplished a lot by making it here, and I look forward to the discussion.
Hi, I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And again, congratulations on being here at Nationals.
You're on mute.
You're on mute.
Edward.
I am Edward Volpe. I'm an attorney in Denver, Colorado, and I've been involved with this program for many, many years. I congratulate you again for your success in being part of the national finals.
Would you please introduce yourselves and your teacher?
All right, my name is Wadra Hall, and I'll be attending Cornell University to pursue a career in architecture.
Hi, I'm Sam Stockfish, and I'm joining GCU's Barnabas Pastoral Program, where I'll be studying for my bachelor's in Christian Studies and my master's of divinity.
I'm Haley Howerton. I plan on going to community college for 2 years for cybersecurity before transferring to ASU.
Great.
Oh, and our coaches are Miss Lindblom and Miss Litz.
Thank you. All right. So you know the drill by now. I'm going to read the entirety of the question. I think we all know we're doing question one. When I stop talking, you can begin and that will start the clock. And then we'll do follow-ups with no notes. Okay, good. All right, question one. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
The blog bags taught us that yellow and blue make green. Just as we use the correct amount of each pigment to create the color green, the US government must balance the religious rights of the people with the interests of the government to abide by the social contract.
So we agree with Yoder because general laws should not be used to burden religious beliefs. However, it is challenging to balance education with religion, as education is not a guaranteed right. Yet we must ensure that there is a right balance of yellow and blue to create the exact hue of green for the people.
Wisconsin's compulsory school attendance law, when applied to the Amish community, was held in violation of the First Amendment's free exercise clause. Under the test established in 1963, Sherbert v. Verner, the state did not prove a compelling state interest. The court explained that Amish children leaving school would not harm them or the state.
Furthermore, Chief Justice Berger explained that by exposing Amish children to worldly values, the attendance law substantially interfered with religious development. We agree with the opinion of the court because the state failed to meet the requirements of strict scrutiny, which should be applied to all free exercise cases. Additionally, education is not a constitutionally protected right, making the compulsory education law an infringement on the Amish religious freedom, thus failing to meet strict scrutiny.
Importantly, 1973 San Antonio School District v. Rodriguez held that there is no fundamental right to education. While the right to education is not in our Constitution, the spending and necessary and proper clauses in Article 1, Section 8 allow for federal education funding. Additionally, state constitutions outline funding, create guidelines, and place limitations that affect school systems.
For instance, Sections 1 and 9 of Arizona's Constitution establishes a general and uniform public school system and requires proper funding for its maintenance. As well, 22 states have declared education to be a fundamental right. Even though the Constitution doesn't guarantee education as a right, the Supreme Court and Congress have declared that if the states provide an education, it must be done equally. So 1954 Brown v. Board of Education used the 14th Amendment's Equal Protection Clause to provide equal access to education by desegregating the schools.
Additionally, the 1974 Equal Education Opportunities Act and 2015 Every Student Succeeds Act are attempts to provide equal opportunity in education for all students. Even so, education is not a nationally recognized fundamental right.
While education is not a guaranteed right, we do see that the courts have attempted to balance free exercise of religion with other rights. The court first used the belief action distinction established in 1940 Cantwell v. Connecticut, then shifted to the standard of strict scrutiny and compelling state interest established in Sherbert. Then 1990 Employment Division v. Smith denied 2 men compensation after being fired for consuming peyote as part of a religious ritual.
The court abandoned Sherbert, shifted back to belief action distinction, and used the rational basis standard. Scalia explains, the free exercise clause protects religious beliefs, but it does not insulate religiously motivated actions from laws unless the laws single out religion for disfavored treatment. In response, Congress passed the Religious Freedom Restoration Act of 1993, which restored the use of strict scrutiny. The legislature argued that the court had effectively overturned case law, including Yoder and Sherbert, which used strict scrutiny to examine restrictive religious laws.
Seeing this in application, 2014 Burwell v. Hobby Lobby held that the government must provide exemptions to the contraceptive mandate of the 2010 Affordable Care Act, which violated RFRA. So the court sided with the religious beliefs of a corporation over a woman's right to contraception, explaining that the government had substantially burdened religious freedom by not accomplishing the government interest in the least restrictive manner.
If there's too much yellow pigment or if there's too much blue pigment, the color green will not be achieved. Rather, some unfortunate outcome occurs. In the same way, there's no exact science to balancing religious expression with government protection. All the while, the US government must continue to paint with the right color of green for all the people.
Thank you. We will move into follow-ups. If you could please put your notes away. And Jen, I think we're good to start time. All right. Okay, first question. How should we analyze laws that may have an impact on religious beliefs? And let's maybe use the Hobby Lobby case that you finished with and tell me whether you think, what analysis should we apply there, and do you think it was the right decision?
As we stated in our essay, we believe strict scrutiny should be applied to all free exercise cases. This is because it is the highest standard of the rational basis intermediate scrutiny tests. Specifically, I believe, strict scrutiny should be applied because free exercise is included in our Constitution. This is seen with suspect classifications, as in 1971, Graham v. Sorry, 1971, Graham v. The case was held that the state cannot deny welfare benefits to a person solely because of their citizenship status.
Also, with strict scrutiny, it applies to fundamental rights when they're being infringed by government. And so when the court is dealing with rights that are non-fundamental, they often rely on rational basis. So for instance, in 1955, Williamson v. Lee Optical, where the court held that unlicensed persons can't provide eye examinations is constitutional, like a law that prevents people with a law that prevents an unlicensed person to provide eye examinations is constitutional because the opticas couldn't provide evidence that the law had no rational relationship to legitimate state objectives. And so this brought into view that states' laws regulating businesses are only subject to rational basis, while fundamental rights are subject to strict scrutiny.
So let's go to the Hobby Lobby case, right? You said that the state hadn't I don't remember what exactly you said. The state hadn't done the least intervention possible or something along those lines. Do you think that was the right decision?
I believe that it was the right decision because when we have this idea of strict scrutiny and this idea of rational basis, it ultimately has to deal with whether or not it's constitutional. With rational basis, we see that it's often much more up to the individual judge's taste because it's much more about whether or not it falls within the laws of logic, while strict scrutiny is not much more about whether or not the state itself and its laws are compelling enough and for the general welfare. So I would look to another case such as like 1998, Church of Lukumi Babale v. City of Hialeah, which we see that within this religion of Lukumi Babale, we see that animal sacrifice is a legitimate belief and that under the free exercise clause, it should be protected. Yet for many individuals that would look at this case, they would say it doesn't really make sense to sacrifice animals when there isn't really like it's unusual treatment of animals and so forth. But yet we see that strict scrutiny was applied to this case because free exercise is within the Constitution and therefore one's biases shouldn't necessarily be the factor within it.
Thank you.
You've indicated in your response that you believe that the Yoder decision was correct, that you agree with the Yoder decision. And it's clear from that that the Supreme Court did not take into consideration the child's feelings or beliefs or what they wanted. Do you think that the Yoder case should have addressed the child's beliefs or desires?
I would argue it did, although not directly in the statement that they provided. When looking over the transcripts of the case, the justices did state that the children themselves had all agreed to their religion and none of them were likely to differ from that religion.
It's also important to note that education for children is also regulated by the parents themselves, and the court had previously established this in 1923 Meyer v. Nebraska and 1925 Pierce v. Society of Sisters, which just shows that students, especially children, aren't able to actually control whether they want to go to a public school or not, and it's up to the parents themselves.
Very good. You talked about the Church of Babalui, Lukumi Babalui, in your comments so far. And the city was not allowed to ban animal sacrifice as part of a religious ritual.
Mhm.
Is it also true that a religious group can use a prohibited drug substance as part of their religious ceremony if it has been part of their history of their faith?
As we mentioned in our essay with 2005 employment district, the courts held that that cannot be used, that religion cannot be used to overturn laws.
I would argue that the cases are very different from one another. With the Lukumi Babalu, the court ended up challenging the accusations by stating that that animal sacrifice, these people would end up using the corpses or the bodies as foods for later consumption. And not only that, with animal sacrifice, it's not very much different than butchery, which is allowed within the state because we have steak and so forth. And so when we have this idea of the peyote being used within context, it doesn't necessarily mean that they should be allowed to, because they're, despite their historical context of use.
Also, the court has continuously made the claim that people can't avoid the law because of their religion unless it substantially interferes with their religious beliefs. And we can see that with in 1879 Reynolds v. United States, where the court held that Congress can prohibit polygamy. And even though polygamy was a practice of the Mormon religion for a century before, we could see that the court still were able to show that just because this is your sincere religious belief and is a practice that has been used for a long time, it does not prevent you to abide by the law.
How would you deal with weighing the child's interest versus the parents' religious beliefs in a case of, say, forced marriage and childbearing of young girls in a ultra religious sect?
I believe the child's right would be placed ahead of the parents. In the cases that Watt had previously mentioned with education, the parent is held to a higher standard because of in loco parentis, where schools act as the parental unit of the school. So the parents choosing to put them in there is the parents' agreement that the school will protect the child. With arranged marriage, however, that does not apply, as marriage is not seen as a replacement for a parental figure.
It's also important to note that the government itself protects everyone's right to life, liberty, and the pursuit of happiness, and that includes children as well.
You can finish your sentence unless you want to be done.
And oh yeah, so and in a previous court case where a parent had used religious instead of providing her daughter with medical care, she used religion on spiritual belief in order to cure her, and the child ended up dying, which just shows, and she ended up getting convicted for it, which comes to prove that even though parents often provide a source or direct their children in a religion, and in that instance, it doesn't prevent the government from putting in boundaries and when it actually violates the children's life, liberty, and the pursuit of happiness and their fundamental rights.
Great job. All right, take a breath. You're done. That was awesome. Way to get that in there. You really elaborated on that point beautifully, knowing you were on the clock, and a lot of students would have just taken the pass and gotten saved by the bell. So great job. I actually thought that was a great way to wrap up our follow-up and tie it back to kind of first principles. It's a little bit of a curveball question because it's easier to think about the academics of Wisconsin v. Yoder. It's an education, but when you get to things like bodily integrity, right, which you were touching on, then how much trust are we going to place in the parents? When does the state intervene? When is there a compelling state interest to protect the child or to at least hear from the child? So I thought you did a great job with that. Good teamwork overall. I liked your prepared remarks, and I was trying to get you with the Hobby Lobby example to come out with maybe some opinions on whether that was rightly decided. You didn't take my bait, and so you kept with your strict scrutiny argument, which is technically correct. I would say that you had already proven to us that you knew that, right? So we already knew you knew rational basis and strict scrutiny. So, obviously I know you're working with nerves, but if you can drill down on that and apply the test, which is what I was trying to get you to do, and tell me, where you would come out, that puts the cherry on top of the answer. But you certainly took every opportunity in the follow-up questions to show us how much you knew with other cases that you hadn't cited in your main argument. So great job. It is very, very clear that you all prepared very well. So you should be very proud of yourselves.
I agree with Judge Johnson's remarks. I thought you did very well. Writing down a number of the cases that you had brought up throughout the discussion, and you seem to have a good grasp of the cases that are applicable in this area, and that's really important. I do also agree that it can be a good thing to be able to express your opinion about some of these decisions. You're entitled to a voice, entitled to your thoughts, and that also helps us to sometimes see that you're taking a position and being able to defend it. You had indicated pretty early on that you were in agreement with the Yoder decision, but there's a whole lot of things that have happened in the last 50 years in this area. And so I think it's important to do that. And I did like the discussion about the strict scrutiny. You truly did demonstrate to us that you understood that. And I think that was a good area for you to touch on. So well done. Thank you. We really appreciated it.
I add my own congratulations to you for the level of understanding that you have developed. I noted many times that you came up with individual cases in responses to our questions. That tells me that you've got a mental library here that you have developed and have ready for your use in the event you get questions such as we were asking. In your initial presentation, you came up with Yoder and Cantwell versus Connecticut, Employment Division v. Smith, Sherbert versus Werner. It might be helpful if you would just add one comment concerning the rulings on those cases. Sherbert an employer couldn't fire an employee because of their refusal to work on a Saturday. And I thought that was very, very interesting. I liked your discussion of equal access. Brown versus Board of Education and the Equal Access Act. I thought that was very good. You did hit Burwell versus Hobby Lobby, and 2 times you cited the Church of Lukumi Babalui with regard to the slaughter of animals as part of a religious ceremony. As the court pointed out in that case, there were chicken slaughtering plants just down the street from the church. So it was an imposition on church belief to deny them the right to slaughter and eat chickens as part of their religious ceremony, when the Purdue company was supplying the entire country with the bodies of chickens. I like the reference to Reynolds v. US, where the court said, your right to freedom of religion is not absolute. That was the essence of that ruling. Just because you believe in polygamy doesn't mean you have the right to do so. And if there are laws restricting polygamy, it serves a legitimate state interest and is not an undue imposition upon your religious faith. This is the first time I've heard Meyer versus Nebraska, and I will have questions for future teams with regard to that. But the fact that you knew it was very impressive. With regard to the use of peyote, you got the Smith case correct. You did not have in your command Gonzalez versus O Centro, which said that the Native American church can use peyote, even though prohibited by federal law, if it is part of their religious ceremonies through their history. And so that is a little bit different from Reynolds in the sense that it allows a prohibited drug to be used in the religious ceremonies. But other than that, I thought your recitation of cases and principles was excellent. I congratulate you. I congratulate your teacher. You should thank her for what she has given you over the course of this year.
Okay, a round of applause to you for a job well done.